My name is Stephanie Bowe. I'm with the Louisiana State Bar Association, and welcome to our Law Talks virtual workshop series. Today's Law Talks is on child custody, visitation, and grandparents' rights, and we have attorney Amber Shepard with Shepard Law presenting on these important topics. And Amber has done this multiple times, and she is stepping in last minute to do it tonight. So thank you very much, Amber. If you want to go to the next slide, I'll go over a few things before we get started. So we need to go over a couple important reminders. First, this presentation is being live streamed on Facebook. Questions will be taken at the end if time permits, and they will be answered live. If you are watching live at a library, you may walk up to the computer to ask or submit your question to library staff. If you are watching by Zoom, you can please submit your questions in the Q&A section. If you are watching via Facebook, please submit questions in the comments section on Facebook. Please note that these comments are public and they are accessible by anyone during and after the presentation is over. And if you don't mind going to the next slide, our next reminder is to please note these disclaimers. Any information provided in this presentation does not and is not intended to constitute legal advice. Instead, all information, content, and materials are for general informational purposes only. No viewer of this video should act or refrain from acting based on the information provided in this presentation without first seeking legal advice from counsel in the relevant jurisdiction. If you need assistance finding legal help in Louisiana, you can go to the Louisiana Civil Legal Navigator or the LSBA's Find Legal Help page. The LSBA's inclusion of a program is not deemed to be a statement or an endorsement of the views expressed therein by the LSBA or any member of the LSBA. Speakers on LSBA programs were carefully selected for their knowledge, but neither the LSBA nor the speaker warrant that the presentation or materials were free of errors or will continue to be accurate. Statements in the presentation and the materials should be verified before relying on them. Opinions expressed are those of the speakers and do not necessarily reflect opinions of the LSBA, its sections, or committees. Views expressed are those of the authors and contributors only. Whew, okay, so now that we got through that, I'm going to go ahead and turn it over to Amber and let her introduce herself and continue on with this topic.
Okay, well, I can't see y'all, but y'all can see me, so hello. I am stepping in last minute on this, but I've presented it for years before, so y'all are in good hands. And just so if you hear a dog barking, it is not Tubbs, who is my best friend. I'm actually dog sitting a doodle named Toby. His full name is Toby David. But he was just in a chair next to me, and that's some of his treats. So anyway, I just wanted to point that out for y'all. If y'all have questions while we're going through this, I probably am going to answer them as we go through, just with the presentation. But if you comment at the end, they'll read them to me and I'll answer them. But don't be afraid to ask questions if you have any. My name is Amber. I'm a lawyer. I'm licensed in Louisiana and Mississippi. I did family law for a very long time, including adoptions, lots of custody, which we're talking about. I'm also an assistance dog author, which means I write about service dog laws, emotional support animal laws, because you can see my best friend Tubbs is my service dog. I'm also a member of the Louisiana Bar's Legal Services for Persons with Disabilities Committee. Anyway, I enjoy doing these presentations and making the law easy to understand. And I try as much as possible. It's not in the disclaimer, but I try to make jokes as I go along the way. It's not to make light of any situation, but I know how boring it can be to hear a lawyer talk about the law. So I use my hands a lot. I'm not Italian, I'm Cajun, but I do my best to keep y'all awake. This is my best friend Tubbs. She's an 8-year-old Labrador Basset Hound mix. She was the first therapy dog used in St. Tammany Parish. She worked with trauma affected children and grown-ups. She has her own bar card, just like a lawyer does. It doesn't mean that she can practice law, but I joke that she probably is better than some lawyers. I'm kidding. She's not. She's a dog. She can't talk. She was the grand marshal of a parade. She has her own coloring book, and she gets her name Tubbs Honest because she likes to eat. Anyway, that's that. Let's get into why you're here, okay? And if you see me and I'm looking down at my phone, it's because I'm looking to make sure that I am on time. Because, you know, us lawyers, we like to talk a lot. And now I'm sitting here trying to put it into my phone while I'm talking, and I just typed in calculator. Girl, no, you're looking for clock. It is 5:30. Oh no, I don't even know what weekday. It's a weekday. Hang on. Okay, good. We're good to go. All right, let's hop into it. The different types of custody and different legal terms, because if you're here, so you want to hear it from the horse's mouth from a lawyer about what these words are. But if you even type it into Google, you get 19,000 different answers for all these different things. And of course, we're in Louisiana, right? So some of our terms may be a little bit different than something your cousin Susie went through in Idaho. Potatoes. I'm just kidding. Okay, so we're going to talk about legal custody and then physical custody. So you may be saying, Amber, what's the big difference there? Legal custody is who, under the law, through a court order, usually has legal rights to the child. And I'm just going to say child, whether you're a grandparent or, a family member, I'm just going to say child, right? Physical custody is who has the actual child in their presence at that time, and they're allowed and awarded that through a court order as well. So yeah, I mean, it's nuts and bolts there. Legal custody, is it shared? Is it joint? Physical custody is the act of having the child with you. And we're only talking about children, not dogs. I told y'all I'm gonna try as much as I can here. Joint custody and sole custody. So this one's kind of easy. So if you have sole custody, what does that mean? It means you are the only one that has legal and physical custody or rights to that child. That's sole custody. Joint custody is when two or more people have rights and legal rights to that child, or children. Full custody and then shared split custody. So full custody is, well, I guess it's probably easier for me to say what the difference is between shared and split. So shared custody is when you share responsibilities and legal rights and time with the child with someone else. So shared can be 50-50. It could be, I can't do math, y'all. That's why I went to law school. 70-30, I think that's right, 79. Whatever percentage it could be. Split custody is just straight down the middle. Even Steven, that's what that is. Shared custody means there's different percentages of how often the child is with one custodial parent or guardian versus another. There's probably a slide on here, but just in case, I do want to mention it because you will see it if you are filing for custody or if you're modifying custody, a term called domiciliary. It's a big old word. And let me tell y'all, I've heard hearing officers, judges, and lawyers all say it differently. So if you think you butchered it, don't you worry. Everyone knows what the word means. I've heard domiciliary, domicile, that means whatever person has that designation, and we'll talk about how you get that, but whoever has that designation, I'm trying to act like it's diagnosis, designation of domiciliary in the event that you share custody rights with someone else, you are obligated to tell them about what's going on with the child. If you guys can't come to an agreement, whether it's education or it's medical, if you can't come to an agreement, the person who has that domiciliary or domicile status can make that decision by court order. And the only way that can get overturned or overruled is if and I'm going to say parent here, okay, but whoever the person arguing is and has rights, the other parent has to go to court and say that was the wrong decision. That's difficult to do, but it does happen sometimes. And normally, if you're going to do that, if someone says, hey, this domicile, you see, hey, I'm doing it now, the domiciliary parent made the wrong decision or they were making bad decisions, then usually you'll modify and say, I want that status now. And the domiciliary parent gets what is it, tax credit, tax deduction. But don't worry about that. That's getting into the weeds. That's just by statute. People agree all the time to split that and say, if you have 3 kids, maybe mom gets every even year, dad gets every odd year, the other parent gets every odd year. It just depends. There are different ways that you can do that. Give me a second. Let me clearly Amber needs some coffee. I feel like I'm missing something with domiciliary. I don't know. Anyway, we'll just move on to the next one. The difference, I'm going to call it different types of folks that can be involved in custody. So you've got the parent, right? Whether that is biological parent or an adoptive parent. That's who we're looking at. And custodian would be, we're going to talk about provisional custody by mandate, or the custodial parent. So the custodial parent is the one that has that child in that moment. So if they're exercising physical custody or actual custody in that moment, doesn't matter about domiciliary or anything, but in that moment, they're the custodial parent. So you'll see that sometimes in consent decrees. So if y'all agree to something about the custody, or if you're changing something and y'all agree, or the court orders it, or a hearing officer orders it, they may say, an example would be like, in the event of an evacuation, the custodial parent, so that means who has the child, makes the decision on, where to evacuate to. And that doesn't mean that is actually what, happens, but I'm trying to give real world examples here. So in a nutshell, legal custody, physical custody, legal custody is like words on paper. Physical custody is who is a child in the present. Joint custody, more than one person. Sole custody, only one person has legal rights. Oh, Toby decided to say hello. Say hello, Toby. He wanted to know about custody too. Full custody, split custody, and shared. And then the different folks that hang out in the realm of custody, which is parent, custodian, and the custodial parent. Okay. What the courts consider when they are establishing custody. And if you're sitting here wondering, like, Amber, all this legal stuff is great, but how do I get these forms? At the very end, okay, Toby. You do not have to have custody, Toby. You're a dog. At the end of this presentation, we have a big list of links. And if you're in a library, your librarians have these links as well that have all of the forms to establish custody, modify custody, or if you need to get a protective order, an emergency custody. So don't worry about that. I'm just giving you the broad strokes here of what everything means. But the forms, you can access them after this presentation. Okay. Parent versus parent custody cases. So this is when two parents, again, biological or adopted, an adopted parent, have split up for whatever reason, and they are trying to establish, I was gonna say modify, but it's a little bit different, establish custody. The court's gonna look at, is there a history of family violence? So that means parent on parent, parent on child, the other parent on child, anyone that's lived in the home or been around, the household. Is there any allegations of violence? It doesn't mean that there has to be a criminal action or a protective order in place. Of course, if you do have that obviously weighs, in your favor as well. But if you can present evidence of a history of family violence, that is something very important to the court. And we're going to talk about this. I think it's in the next slide. The best interest of the child. Oh, look, it's the next sentence. Can y'all tell? It's like y'all, I didn't even practice. You're like, we know, Amber, we can obviously tell. But it's almost like I know it's like the back of my hand almost. Um, anyway, so they're looking at a bunch of factors. Actually, let me see. Here we go. I'm gonna go back to the slide after this, but whether it's parent versus parent or parent versus non-parent, okay, we're gonna come back to this. No matter what, and this is also going to be considered with grandparents, the court is looking at the best interest of the child. This is a phrase, it's a legal phrase. There's a statute. I want to say it may be 134. I can't remember off the top of my head. But there are 14 statutes. There are 14 factors that the court looks at. And I'm going to tell you, I'm going to go through them, but it's not like there's this checklist where a judge is like assigning points like pros and cons. I mean, yeah, but they look at the totality of the circumstances of the entire well-being of the child, which includes these factors. So they're going to look at when they're awarding custody, when they're establishing it, the potential for abuse in the house against the child, around the child, the love, affection, and emotional ties the child has to that parent and that person. So, I'm just using examples. These are hypotheticals, right? Let's say you've got a mom and a dad and they've been married for 10 years, but mom's been gone for 8. She hasn't seen the child since the child was 2. The child may have not, in theory, right, with the years gone, may not even have a relationship or remember mom. That's, if they were to award mom, split 50-50 custody, how would that affect the child? And then these are hypotheticals, okay? Every situation is different because all these 14 factors are different for everybody. They're also going to look at the capacity and disposition of the parent or of the other person to give love, affection, and spiritual guidance and to continue education in rearing the child. So if there's a history of the person that's asking for custody to establish custody of not making the child go to school, not keeping the child clean, things like that, they miss school, they're late to school, that's important to the court. The capacity and disposition to provide food, clothing, medical, and other material needs. Now, this means you're not neglecting the child, right? Like, do you have a job? And if you're disabled and you don't have a job, that doesn't mean that you're not going to get custody of your child. That is not what that means. This takes into account all the factors there, all the support that you have. And anyway, let's see. Length of time in a stable environment. So like that hypothetical, they've been with dad for 8 years, right? Like that's a good amount of time in a stable environment. They're going to look at, is the parent or does the parent have a history through no fault of, well, through the fault of their own, I guess, of moving around constantly, not like moving the child from school to school. They're not moving because of a job. They're not moving because of housing. Like they're just unstable, going couch to couch with other people. And, I know when divorces or separations happen, like there's a period of transition here, and the court understands that as well. It's just they're looking at everything together of what's in the best interest of the child, because in the court's mind, stability for a child, and especially for a child that is very young, is very important, for that child's well-being and safety. The permanence of custodial homes, I kind of mentioned that, like if you're moving around a lot. The moral fitness of each party. Now, lawyers like to get into the weeds on this one. If your job is legal, you're fine. Okay. Y'all can kind of read between the lines on that, knock on wood, right? Okay. If you're doing nefarious things, then perhaps not. Your orientation does not go into this either. It's basically, what you're doing, are you doing around the kid? Or could the kid have repercussions from it? Obviously, it is a big deal, the history of substance abuse, violence, and criminal activity of the person that's wanting custody. That's a big deal to the court. And I do like to say this too. We have seen people in recovery still have custody of their children, as long as they have a support system and they're taking, their drug tests and their screens and they're coming up clean. There are parameters that, get put into place, and everyone's different, right? There's a big difference, in each case in each scenario, but I do like to point that out, that just because maybe if you've been sober, for 10 years, well, awesome. That's not going to be held against you at all because you're not currently, using. Toby, I'm sorry, Toby. There you go, buddy. Okay. My dog is not a doodle. This is high energy. The physical and mental health of each party is going to be looked at again in this bubble here. Just because you have a disability, again, does not mean that you're not going to be able to have custody of your child. Just because you were diagnosed with a mental illness, as long as you are in treatment, you're in check. If you are ordered to take medications, you're taking your medications, and there's been no harm to the child, you're fine. There's a difference between that and, having I'm going on the opposite end of the spectrum. I was a curator for mental health court as well, but if you have schizophrenia but you're not taking your medication and you're paranoid, delusional, and that can harm, and usually will harm, the child in your presence. So that's a big deal, but the court wants you to get help. So always the history of the child in the community, like school extracurriculars and friends, they're going to look at that. The child's reasonable preference is part of the best interest of the child. Now, the court does not like putting the child in the spotlight and asking them point blank, do you want to live with mommy or daddy, or, mommy, or daddy, whatever. But at a certain age, the court does listen to reasonable, and I say the court does typically, right? Depending on the situation. Reasonable requests. So if the kid is 15, almost 16, 17, where they want to live is probably going to be listened to maybe a little bit more than a 6-year-old, depending on the circumstances. And when you get into the child's reasonable preference, we don't go into this, but when you start to bring children in to testify, that's called a Watermeyer hearing. It's, closed chambers. The parents aren't in front of the kids. They're like behind. It's a traumatizing thing for a child to have to testify about their parents. So, most lawyers tend to only do that when it's absolutely necessary. And if there's a history of violence or substance abuse or whatever the case may be, usually that may happen. The willingness of the parent to facilitate a relationship with the other person. And remember, I'm saying parent, but I mean the other grandparent, whoever it is. You do not want parents alienating affection, that is a fancy legal term, or poisoning the child against the other parent in their presence. Does it happen? I know it does. Just from being a baby Amber, I heard it from my biological father. My mom never did, but I remember almost everything that they said. I've been adopted since, so it's fine. Thanks. The court looks at that. And if you're domiciliary and you are preventing a relationship with the other party and you do not have good reason, like abuse or anything like that, that could get you stripped of that domiciliary status if someone were to argue it. The distance between the residences of, if you have lived in Louisiana your entire life with this child and then you decide to break up and you want to move to New York City, you don't even have a job in New York City. It's a little bit different than if you want to go move to Bay St. Louis or you want to move to Houston or things like that. And then, of course, the prior caregiving by each party, the history of the child. So who is, taking them to doctor's appointments, school, going to recitals, things like that. Now, of course, if someone does offshore work, it's going to be a little bit different than if someone, worked in town and just didn't do these things. But again, all these factors, it's a lot of factors. I talked a lot because all of this molded together is going to be the best interest of the child and what the court is looking at when they're establishing custody. So you've got parent versus parent, and you've got parent versus non-parent, which is going to typically be a grandparent, sometimes a step parent of the child. When they're looking at that, of course, the best interest still factor. The history of family violence is still a factor, just like it is in parent on parent or parent versus parent. But they're also going to look at would there be substantial harm if this child had no more contact with this person? And there's a difference between custody and visitation, which we're going to get into. Okay. Well, I guess we're going to get into it in the next slide. All right. So let me see. Look at that. Okay. Well, let me just look at me. I'm like 2 steps ahead. I'm like Aladdin. And then we said 2 jumps ahead in Aladdin. I don't really remember. But anyway, we're going to get to visitation, but let's talk about, we just talked about establishing custody. Now we're going to modify custody. So there's 2 different ways that you can go about modifying custody, and it depends on how custody was established. We've got 2 blocks here for a reason. One was the establishing of the custody, a consent decree. That means y'all came together, or your lawyers came together, y'all agreed on something, you both signed it, a court signed it, there wasn't a trial. Or you went to a hearing officer conference and y'all talked to him or her about your situation. They made a report, neither one of you objected, it became a court order. Consent decrees, in order to modify them, because y'all agreed to it before, in order to change it later, if you want to modify custody, there has to have been a material change in circumstances since the last time. So that's in quotes because that's part of a legal statute. So you have to have that language. And how would modifying it change, or how would your proposed modifications that you're asking for affect the best interests of the child? So, for example, let's say last time y'all went to court, y'all agreed on 50-50 custody. Every other weekend they're at dad's. Yeah, okay, 50-50 every other weekend they're at dad's. At the time, dad was working in Mandeville, so he could watch the kid on the weekend. Well, he got a new job. Dad got a new job, and now he's offshore every 2 weeks. Well, he can't do the every other weekend. You can't have 50-50 the way that it was split because he's not home for 2 weeks at a time. So that's a material change in circumstance. Another example would be, if mom was sober the last time y'all agreed to something and she got a DUI with the kid in the car. That's a material change in circumstance. Something happened, and putting into place that there needs to be or modifying custody, saying that visitation maybe needs to be supervised, or there needs to be a breathalyzer test taken before they accept the child's physical custody to have visits, whatever the case may be. Something happened that y'all did not talk about or argue about before. That's the big important thing for a consent decree. What happened? What's changed? And is it a material change since the last time? Like, what wouldn't be a material change is, let's say, I'm just making this up, dad moves 3 neighborhoods away and the child has to take maybe a different bus to the same school, and you're wanting to change custody because of that. That's probably not going to be a material change. It's a different bus, yeah, but it's the same school. It's not that far away, and what's the harm that's going to come to the child if we don't change it? A considered decree, so we're on block 2. Considered decree is there was a judge made a ruling. There was a whole trial, a whole thing, judge made a ruling. Those are much harder to change than a consent decree. So that point, the legal system looks at it as, y'all came to us already. We listened, we heard evidence, we listened to witnesses, whatever the case may be. Maybe there was a evaluation done. Why are you coming back now to change it? They're very difficult to change unless there's a good reason for it. And does the harm of the changes that you want to make outweigh the benefits? It really has to be a substantial reason for a change to be made to something that was a considered decree at a trial, or was made after a trial. You know, would the way that the current custody arrangement is be harmful to the child? So if, you know, the child had to call 911 because dad OD'd, yeah, that's continuing unsupervised, you know, no drug test in place kind of thing. Dad's not in therapy, you know, maybe the child's in therapy now because of that traumatic event. That's a big deal. That's a big thing. They're going to listen to that. You know, or your dad gets in a wreck with the kid in the car. They're under the influence. I know I'm using that a lot, but like, I'm gonna be honest, it's 2025. This happens a lot. Anyway, visitation. So we talked about custody. Okay. So you have legal rights to the child. Visitation. You don't have legal rights. You know, you can't be making decisions for them, medical decisions, educational decisions, childbearing decisions, but you can visit with them. How do we do that? Hang on. I need a little sip of coffee. Okay, so different types of visitation. There's unsupervised, which is like, that's the normal kind, right? It's what everyone thinks about. Then there's supervised visitation. Let's go with unsupervised visitation. And I say normal, you know, what's normal in 2025? I don't know. But for the child, supervised visitation is not normal, let's be honest. Okay. Unsupervised. This is happening in most of your standard cases, joint custody cases, shared custody, unsupervised visits. You go with mom, you go with mom, you go with dad, you go with grandpa, you know, you're doing whatever you need to do. Everyone trusts you to do a good job watching the kid, right? Granted, when there's no issues or problems, the non-custodial parent can do activities that they want, and have the child where they want, as long as the child is safe and returned on time. So that's within reason. I don't know if you can go, well, okay, that's my opinion. I don't know if you can really go across state lines without like saying, hey, we're going on vacation or we're doing whatever. But anyway, you can basically do whatever you want. You want to go to Chuck E. Cheese, you want to go hit some golf balls, you just want to go watch Netflix for 7 hours at the house, that's fine. Do what you want to do, Holmes. Supervised visitation. That is when it is in the child's best interest to have another adult present during the visitation. This can be in the form of a relative. Usually it has to be agreed on. So if you're getting supervised visitation, there's a list of people that are allowed. Sometimes it says, you know, supervised visitation, person, you know, to be approved by the other parent, or, you know, here's 7 people that we trust, as long as they're not doing anything crazy, like they can be the supervisors, or a sheriff. And if it's a sheriff and it's a supervised visitation, the parent who's having the visitation supervised is going to be the one that's going to have to pay the sheriff to supervise. Anyway, there's discretion that the court can have on this, and they're only going to order supervised visitations if again, if there's harm. I'm autistic, y'all, so sometimes I'm looking around and I gotta like find the word in my brain. If there's going to be harm or potential harm that can come to the child. So the law requires supervised visitations in these instances, and there could be others that aren't on here that a judge may agree to. Sir, the dog just asked to go outside. No, you just went. Well, you have to wait. You have to wait. We're talking about supervised visitation. He has no idea what I'm saying. Family violence, physical abuse or neglect, sexual abuse, criminal misconduct. And criminal misconduct doesn't mean like you got a speeding ticket. Okay. It means, you know, some serious misconduct there. Physical violence, you know, aggravated type crimes, drug crimes. Repeated interference with the other parent's visitation is another one. You know, if you have tried to kidnap the child, I'm like, well, I'm not laughing, but you know, you left with the child you weren't supposed to, you secreted the child, and you know, the court may say, hey, we don't trust you, so you have to have supervised visitation for the time being. And of course, drug use, right? And I'm going to put in there alcohol abuse as well. It really, that's another one too, that a judge may agree to. It's not in the law, but that is something. Okay. Who's entitled to visitation? All legal parents. Sir, it is not time. All legal parents, unless it's not in the best interest of the child for the visitation. So if them visiting would seriously endanger the child. So this means even supervised visitation would still be damaging to the child. An example, it depends on the situation and the jurisdiction, meaning the court that you have. But I used to do sync cases, so child in need of care. So some judges would allow visitations at the jails with the parent, but some wouldn't, because the fact that the parent was in jail could have traumatized the child. But they do have sometimes the parent would get out for visitation and go to a third location. But there was always deputies, obviously there as well. Who also can have visitation? Non-parents. So this is a big one. That is just visitation. So you don't have legal rights, but you do have the right to visit the child. This can be family members, and a big one is former step-parents. Y'all have lived together, family members would be like, if I'm making this up, the parents have lived with the aunt, since the child was 2, the child's now 11, the aunt still wants to visit with the child, something like that, because they became like a de facto mom kind of thing. Former step parents, same thing. You've been with the child, this long period of time, and just vanished, literally it would be like just vanishing from their life would be absolutely detrimental and not in the best interest of the child. That's another example. And then grandparents. So grandparents, and we have a whole section on this. Grandparents' rights are limited because the courts still want the parent to have the right to make decisions about how to raise their child. But there are times where it's in the child's best interest to allow grandparent visitation, and we have slides on when that happens. Boop. Grandparents' rights. Okay. Grandparent custodial rights. So this is not just visitation. This is grandparent is getting custody, some custody. It could be sole custody, it could be shared, it could be split, some kind of custody with legal rights that they're either sharing with the parent, but if they're sole, obviously they're not sharing it with the parent. This happens, or it can happen, if the state has custody of the child due to abuse or neglect. So that's the sync cases that I was talking about, child in need of care. There's evidence of child abuse or neglect by the parent that filed for custody, and a grandparent comes in and says, this has been going on. Here we are to intervene. The child needs to come with us, or we need to, have rights over the child. An award of custody to either parent would cause substantial harm to the child. We're gonna talk about that in a second. Both parents with legal authority agree to the grandparent custody. They agree to it. So it doesn't, you don't have to go, those parents don't have to admit to A, B, or C. They just feel that, it's in my child's best interest. Both of them agree. We want them to go to grandparent A and B, or maybe they want to split between grandparent A and B, mom's parents, and then grandparent C and D, dad's parents, or, mom, dad, mom and mom, dad and dad, whatever. If they agree to it, as long as it's in the best interest, the court is going to allow it. So that would be considered what class? What kind of decree? Consent decree. See, we're learning, we're adding on these blocks. If the parents are abusing the child, the grandparent can file a protective order on behalf of the child and seek temporary custody. Those forms are linked at the very end of this presentation. And it's for not just grandparent, there's grandparent specific ones, but then there's also parent ones. No, I think I may be getting that confused. We have all the forms. But anyway, you would file for a temporary restraining order and an ex parte, that not like parte, but like It's EXPARTE, ex parte motion for custody. Just means, hey, court, and there's oh my gosh. There are extreme circumstances going on here, and we need to put this child into custody, and away from the parents. There's going to be harm, drug abuse, child abuse, physical abuse, threats of violence against the child or themselves if, you know, a parent is expressing suicidal thoughts or harm. Okay, so a grandparent can request visitation. So we just did custody. This is when grandparents can ask for those legal rights, custody of the child. Here's when they can ask, or reasons maybe they may want to request just visiting, saying, I love my grandkids. I just want to make sure that I'm still seeing them. I know that they have, you know, a parent or someone in place that's taking care of them. We don't want to overstep that. We just want to visit with them. This can happen if the parents are married. So the parents of the child, right, are married, and the grandparent's child. So let's say I'm the grandparent. My daughter had Susie. My daughter has passed away. So there's no connection for me in theory to Susie except through the dad of Susie, my granddaughter. The grandparent can request visitation rights at that point. So if their child has died, has been sent to prison, and they're going to be in prison for a hot second, right? Like if they're just in like St. Tammany Parish Jail for like 3 months, I don't know if that's going to fly because you're probably not going to get a court date within that time period, but y'all know your situation. Always talk to a lawyer first. So if the child's died, been sent to prison, or has been declared mentally handicapped, there's been an interdiction done, anything like that on the grandparent's child that is the parent of the grandchild. It's a lot, right? Okay, another one is if the parents of your grandchild were never married, but they were living together, same situation. Your child's died, sent to prison, or declared mentally handicapped, interdiction. That's another way. So married, these things happen. Unmarried, but living together, and these things happen. If they're married, if the if the parents of your grandchild have been married, but they've been separated for at least 6 months, and there's extraordinary circumstances. So this is just for visitation, okay? Let's just say there's extraordinary circumstances. They are on drugs, but they're in rehab. You're not coming in to say, I want custody taken away or rights terminated right now. I just want to be able to see my granddaughter, my grandson, and make sure that they're okay. That's usually when that happens. The grandchildren have been placed in foster care due to a parent's abuse or neglect. So that's the sink cases. And the parent's parental rights have been terminated. So in this situation, let's say kids taken away, the rights of your son or daughter were terminated by sink court. They're placed up for adoption. Maybe you don't have the means to adopt them. You don't want to adopt, I don't know, whatever the case may be. But you still want to visit with them. You can intervene and ask for visitation rights of that child. Provisional custody by mandate, another giant legal phrase. Okay, this is a piece of paper that the biological or adopted parents, depending on the situation, have agreed to, and gives specific rights just for a year, or until it's revoked before, if it's before that year, or the person dies before that year. So it is a piece of paper. It's a form. You can find them online. I think they're on the Supreme Court's website, which is also linked. That whoever has custody of the child, the legal rights to this child, biological adopted parent, says, I am allowing these people or person to take care of my child, provisional custody by mandate. It has to be notarized and witnessed by 2 witnesses other than you and the other party, right? This is my opinion only. Don't have it be anyone that's related to you. Go to a notary, go to a lawyer's office, pay them to do it, have someone you don't even know be a witness. Makes it easy. A provisional custody mandate automatically expires at the end of a year, but you can revoke it earlier. The only person that can revoke it is the person who granted it. Okay. Um, what does it do? It allows the grandparent or whoever, it could be an aunt, it could be a sister, whoever, to authorize medical care and treatment of the child, enroll the child in school, reasonably discipline the child for, proper rearing, supervision, and training. That's from a statute. Perform other acts as necessary for the child's shelter, support, and general welfare for that 1 year period. Okay. There's a note here on the bottom. Some schools, and I'm not a teacher, I'm not a superintendent, I'm just telling you throughout the state, these are just what we've heard. Okay. Some schools won't accept a provisional custody by mandate of a grandparent. You'll have to get custody, but some may accept a power of attorney. Anyway, when in doubt, get a custody agreement. Oh, I was like looking down. I was like, I feel like I have a lot of time for questions. I'm gonna open it up early for questions. I'm
And
sorry, I got like 20 minutes left.
and that's quite all right. So, as Amber mentioned, we'll open it up for questions now. So, as a reminder, if you're watching on Zoom, you can enter those into the Q&A section. If you're watching on Facebook, you can enter those into the comment section, and we'll get those to Amber so she can answer them live. And then there is a little bit of a delay on, I think it's about a minute or two delay on Facebook. So while we wait for that, if you don't mind going to the next slide, I'll tell folks a little bit about our legal help access points, which our Law Talks program was started as a program of the legal help access points to help folks, particularly in rural communities, get access and assistance with their civil legal issues. These access points are physical computers or booths that allow users to access a spectrum of services and information. They can also get customized legal information and referrals. They can see if they qualify for legal aid. They can schedule meetings with legal aid attorneys, and they can also attend virtual court in participating jurisdictions. These access points are currently in libraries throughout Louisiana, particularly in Lake Providence, in Faraday, and in DeRidder. And then we have one in the LaSalle Community Action Association in Harrisonburg, and we have one that is currently in the St. Bernard Parish Government Complex building, which is in Chalmette. So for more information about these access points, you can visit the link that's listed on this page. And then if you'll go to the next slide, I can cover some of the resources that Amber was referring to. So this is a flyer for our Find Legal Help page. As you can see at the top of the page, there's the website. If you can access it by going to www.lsba.org /go/find legal help. And we first suggest folks try the Civil Legal Navigator. It is kind of a diagnostic tool for users where you can enter some of your information, some of the legal issue that you're experiencing, and it will guide you through and give you the information you're looking for. And it can specify specific issues that you're having. And it will also lead to court forms as well, if there's a court form available for your legal issues, such as a petition to establish custody, a modification of custody and visitation rights. Those ex parte motions that Amber was referring to, you can also get access to those through the Civil Legal Navigator. You can also go to the self-help resources and legal forms section, which is 1, 2, 3, 5th on the list. And there's a list of all of the forms there. So you can see what we have available if you'd like. And then last, but certainly not least, if you are watching this presentation at a later date and you have a question that was not addressed during the presentation, you can go to any of these resources, but you might be able to access our free legal answers, which is an online pro bono program that allows users to log in whenever and wherever they like and ask civil legal questions, which a volunteer attorney may answer those questions through the site. And it's kind of like email. It is private, but do please note, users must meet certain income guidelines to use that website. So let's see, I'm going to do one more check. I don't see any questions that came through. I feel like you might have covered it all, and you were definitely ahead of yourself at multiple points. Obviously, an expert. So before we end, I do want to let users know, if Amber, if you don't mind going, thank you. Um, that please save the date for our next law talk, which is scheduled for next week, actually, on Thursday, the April 17th. It will be on immigration, know your rights. So if you are interested in attending, you can go to the website listed here, louisianalawyersanlibraries.org. You can register to participate by Zoom there, or you can reach out to myself or to Rachel, who work on these programs, and we can help get you situated for that one. But it's again next Thursday, the 17th at noon. And that concludes the presentation for today. Amber, thank you again so very much for stepping in and doing a phenomenal job as always.
You're welcome.
Thanks, everyone. Hope you all have a great evening. And tell Toby we said goodbye.